So my question was, what are the possible implications of the overturning of Roe and Wade for the UK? Well, on one level, it could be argued that there aren't particular implications because the laws are very different in the United States, different justification for abortion. But the main problem here is that abortion has and still remains to be very polarized. So the debate has now been set about being whether you're very liberal or whether you are almost tyrannical. And people who are in favor of any kind of abortion law seem to be anti-abortion law seem to be on the tyrannical side, and it has even been put as an assault on democracy, the overturning of Roe and Wade, and that has caused people in the UK to begin to rethink maybe the way that they look at abortion. And just a quick look on the media, you see that people are very concerned that what they call the minority will become very vociferous and demand a sort of clamping down on abortion. But I think that we could look at implications here and also opportunities. So some of the implications here are that in the under Roe and Wade, it seemed that abortion was a right, the right to abortion. And so in the UK, people also think that abortion is a woman's right. Now, this is problematic in lots of ways, and particularly when we come to look at rights legislation, about how rights legislation is going to be changed in the UK, there might be a push towards having abortion simply as a woman's right. Well, this could be an opportunity, because there'll be an opportunity for people to begin to discuss what they mean by rights, what they mean by duties, and how you enforce rights as well. So it need not be a limit, it might be something we want to explore more. The other problem is conflating abortion with sexual and reproductive rights generally, or the right to access healthcare. And again, this could be an opportunity because it would give us a chance to make clearer definitions about what we do think is healthcare, what we do think is access to healthcare, and separate out some of those really difficult reproductive rights, for example, protection against FGM, from things like abortion. So it gives us an opportunity there. Another thing I found in the media was the suggestion that abortion should just be up to the doctor and the pregnant woman, and that the doctor should decide what is in the best interests of the woman, brackets that, and the best interests is giving her priority, her autonomy priority. Well, again, this gives us an opportunity to start talking about best interests tests and whether autonomy is in fact a ruling principle. So we can have some deeper discussions about what's going on, but always under this framework that it's quite a polarized debate and it's going to be quite a difficult thing to do. But ultimately, what we need to think about is the status of the unborn child, certainly, but also how we change hearts and minds. You know, we're not going to win this by engaging in that polarized debate. It's telling good stories about people who could have had an abortion and didn't. It's giving people support to go ahead with pregnancies. It's thinking about other things that we can do, and also good sexual education and relationships education, and put all of those things in place. So yes, there are implications, but not so much legislative implications, but also opportunities.
Thank you. Questions, Gavin, Chris?
Yeah, the circumstances are different in the UK and the US, but the US, one would have to say, have set themselves up for this by dealing with the issue of abortion in 1973 through the mechanism of a judicial fiat, essentially, with Roe v. Wade. It's different in this country, but we still have a slightly unusual legal framework. And I think that is likely to become an issue because, of course, the 1967 Abortion Act is a piece of permissive legislation to facilitate legal abortion, despite the fact that it is illegal under the 1861 Offences Against the Person Act. And what we're seeing at the moment in the UK, just as in the US, who had lots of campaigning in relation to the justices on the Supreme Court, we're starting to see a lot of noise from those who are, if you like, pro-choice, as they would call it, in relation to the Offences Against the Persons Act, which they will describe as Victorian legislation, in the context of decriminalization. Now, we may be inclined to think that it wouldn't, you know, it wouldn't be great if that happens, but would it make much of a difference? Because we kind of have abortions sort of on demand at the moment. But I think that's a really damaging step, because if the 1861 provisions are repealed, then the 1967 Act becomes essentially redundant as far as I can see it. And of course, the 1967 Act does contain within it clause 4, which provides for a conscientious objection on the part of doctors and healthcare people. So it seems to me that in some parts of the UK, one of the biggest problems, if you see it as that with abortion provision, is that many doctors are choosing not to do abortions, and it can be very difficult in some parts of the country for women to get access to abortion. If the 1861 Act is repealed because it's fuddy-duddy old Victorian legislation, this will completely reopen the necessary discussions about the framework for legislation and regulation of abortion, and that will bring the conscientious objection clause into the forefront. And potentially, if we have a situation, and you can hear the language in the debate, they simply refer to it as normal healthcare, reproductive healthcare. How can a doctor say, I'm not prepared to participate in normal healthcare? And I think that might make life very, very difficult. So I think we ought to be really cautious about perhaps, well, we need to take very seriously the questions of decriminalization, because that will, in effect, there will be dominoes that drop as a result of that, which could be very challenging.
Yes, certainly. And I heard a barrister soon after the Roe and Wade case was overturned, describing the Offence Against the Person Act as enacted before the light bulb, as if it was not an enlightened thing, that you ought to protect the lives of human beings. But then I don't think many people know enough about the Offence Against the Person Act itself.
And,
so
and isn't there another act, the Infant Life Preservation Act from the 1920s, I think 29, I may be wrong. But for a child who's viable, an unborn child that's viable, it's called child destruction, the crime under that legislation. That was not Victorian legislation. That was legislation about, which was not about expelling a child from the womb prematurely, but was about feticide, was about actions to make sure that the child was dead before removing the child. And that it seems to me is another, I mean, it's a very important thing to consider if you have a view which says any kind of restriction at all in relation to abortion, is something which is not part of ordinary healthcare, is contrary to people's rights to access, then you're not just talking about abortion prior to viability, but also about abortion after viability, which of course we have for abortion for disability already. And so that's another sort of case, and I think it might be useful sometimes to think about that case, because it shows that there are it isn't the same as other kinds of healthcare. I mean, there are real problems here, I think.
And that's why we need to make these good definitions in order to clarify the discussion that's happening. This is where a place like Anscombe can do that, whereas other people might not have seen those kind of distinctions. But there is a real worry about it becoming a right, because as Gavin rightly pointed out, where does that leave doctors? And if you have a right, well, is it a right of how you're going to enforce it, and who has a duty to perform it? So those are discussions to be had as well. Last
thoughts, Chris?
Well, my only thought is is in terms of translating, as it were, the concern from the US to the UK, is of course that one of the major concerns, it seems to me, as the issue has unfolded in the US, is people have run to the question of healthcare, of questions of maternal mortality, but of course, in the UK, we have a very, very different healthcare system. So translating the concerns that people have is also in a very different kind of register. That was just another point.
I would just like to make one last thing, which only I on this panel can say. There is a move to remove men from the discussion. That was one of the comments about the Offence Against the Person Act, was that it was enacted by men, no women were involved. Presumably also the same would be said about 1920s legislation. We also eliminate fathers from the discussion. And there's a big issue about, is this just a private issue between a woman and her doctor? And that's another set of things that we have to discuss. We won't eliminate men.
Of course, Roe v. Wade was decided by 9 men, and the overturning of it returns it to the states where women have a vote, as they didn't in Roe v. Wade.